This is NBC 10 at Issue.
We're back now on NBC 10 at Issue with analysis of a new ruling from the U.S. Supreme Court. On Thursday, the court barred the government from restricting the gun rights of casual drug users. The case involved a Texas man who occasionally consumed marijuana. The law makes it a crime for any person who is an unlawful user of or addicted to any controlled substance to possess a firearm. Now, it is the same statute that Hunter Biden, the son of former President Joe Biden, was convicted under in June of 2024 before his father pardoned him. And joining us now to discuss this further is NBC 10 legal analyst Enrique Latoison. He is a criminal defense attorney. Welcome. Great to see you again, Enrique.
Thank you.
So let's dig right into this. How could this decision change things, and what kinds of cases would be affected?
So this is a huge ruling. It does change things. It changes the burden on the prosecution from the federal government, but it also doesn't change a lot of things. Let's take the Hunter Biden case, for example. Everyone knows his case. Of course, he was pardoned, so technically he was no longer guilty of those charges, but he was facing 3 of those charges. 2 of those charges, it would not change anything in this case. 1 of those charges, it would. So 2 of the chargings, which is lying on a gun application or saying that you're not a drug user on a gun application, the Supreme Court did not change anything in reference to that. That is still the law today. That still stands. 1 of the charges that he was convicted of was a person that is a known drug user having possession of a firearm. This is what changes today. What changed before was, in the past, if you were a drug user of a controlled substance and it was illegal, not prescribed, you were automatically, in that case, guilty of possessing a firearm as a known drug user. Now what the law says, just because someone is a known drug user and they're in possession of a firearm, the prosecution must go 1 step further and prove that this person also is dangerous. And it's a combination of being a drug user and being dangerous. This was never the test before. So as of today, this is now the test. So it does change things, but it doesn't change everything.
So what does this mean then for the investigation of these cases, for building these cases, in terms of the evidence and information that law enforcement and prosecutors would have to have?
So in the past, it was very simple. You could just show that the person was using illegal drugs and it wasn't prescribed, and this was a controlled substance. Easy win for the prosecution. Person has a gun, person using drugs, guilty. Now the Supreme Court has said that's not enough. You have to show that the person is possession of a firearm and that the drugs that they're using is making them dangerous. So maybe a particular person uses a particular drug all the time and they're not dangerous and they're just a person that's a functional user. The prosecution has to put the 2 together, has to be possession of a firearm, using a controlled substance, and has to be dangerous. That's what's changing today. They're going to have to go back and look at all their open cases that they have on this particular statute, and they're going to have to see whether or not they have evidence to show that this person is dangerous along with those other 2 points.
Could you see cases that had already been finished and prosecutions were finished and sentences were given out? Could people come back and say, wait a minute, I want another look at this?
Absolutely. I mean, the law is deemed to be unconstitutional. And it's deemed to be basically overbroad and too simple. The Supreme Court basically said that, persons' right to bear firearms underneath the Second Amendment cannot just be taken away when you can't have a nexus between the person having a firearm, using drugs, and not showing that they're a dangerous individual. So in this particular case, when you look at these particular facts, it's narrow, but it has absolutely a huge effect on the usual person. So now, it doesn't say that anybody using drugs can just have a firearm. It says the prosecution must show that this person using the drugs is making them dangerous. I still believe that there'll be certain types of drugs that the prosecution could easily make this case out. And I believe it's probably for marijuana going to be a harder haul and a harder test for the prosecution to make out.
And Justice Gorsuch in this opinion drew a distinction, saying that it didn't apply to addicts or people who are currently intoxicated. What's the significance of that in drawing that distinction?
So the history of why that particular law exists deals with habitual drunkards. It dealt with in the past of why this law was actually instituted is for the idea of someone being intoxicated and not allowed to have a gun. And so that's kind of the history. And when you deal with the laws of the Supreme Court, they go back and tell you why this law actually existed and why we have it. But they're saying today, in today's times, that you have to make that connection. It can't just be this person smokes marijuana on a regular basis, therefore they can't have a gun. They're saying that the Second Amendment rights for that person to bear a firearm is too important over the fact that the government, just saying that they smoke marijuana, so therefore they can't have a gun. They're saying that you got to do more. The prosecution has to do more. They have to make a connection. They have to show to successfully prosecute someone, they have to show instances of danger or show that the person is dangerous. Then you don't have a right underneath your Second Amendment right to have a firearm.
As states across the country make decisions about marijuana laws and what's legal and what's not legal, is this the kind of case that you think will be considered or just have a role to play in some of those decisions?
Yeah, so this is where it gets interesting. Mostly people are prosecuted on purchasing firearms and lying on a gun application. And that's what Hunter Biden, two of his charges he was convicted of. So this is where it gets interesting because the reason why the question is asked whether or not you're a known drug user is because there hasn't ever been an element of a known drug user that's dangerous. So this question is asked on the gun application. So as anyone listening to this broadcast go, if they're a known drug user or they use marijuana or use any kind of drug and they go apply for a gun, you can't lie on the application. You still have to say, yes, I'm a known drug user, or yes, I use drugs and stuff like that. So I think in the future, there's going to be a challenge to that question on the gun application. Why are you asking whether or not I use drugs? I think that challenge is coming down the road. I think that question is going to be turned into something else, or it's going to be eliminated. I think the question might be enhanced to say, do you use drugs or do you use certain types of drugs? Certain types of drugs is going to be a lot easier for the government to make out the person is dangerous. And maybe, that actual question will go away because at some point someone's going to say this question is unconstitutional. You're asking me these questions and it doesn't matter. It only matters whether or not I'm dangerous and I use these drugs. So I think the future of purchasing firearms is going to change based on this case.
Interesting. More to watch on this. Enrique Latoison, great to see you. Thanks for your perspective.
Thank you.